U.S. Supreme Court has overturned Roe versus Wade. Roe versus Wade is no longer the law of the land. Let me read to you from the decision, page 69, authored by Justice Alito. We therefore hold that the Constitution does not confer a right to abortion. Roe and Casey must be overruled, and the authority to regulate abortion must be returned to the people.
I didn't think I'd see this. I mean, if you looked at the trajectory where the court had been, and if you looked at the previous cases, Casey, Roe, it just did not seem like it was going to happen. I mean, there was all this hope in Casey that maybe the court would overturn Roe, and instead they doubled down on it.
For people to understand, that was 1992 was the last time there was a serious challenge.
Correct. So here we are 30 years later. I mean, 30 years later. But I will tell you, it was worth the wait.
It's a victory for so many people who have had an impact on this. If you've stood up for life by supporting work by groups like ours, if you protested, if you were involved in that civil disobedience, and you've stayed committed to an issue when it didn't look good, when it was an uphill battle to fight the abortion industry, the abortion behemoth, and the abortion distortion in our courts, and it has been overturned. Yep. Roe versus Wade is no longer the law of the land.
I did not know if in my lifetime I was going to see this, because so many things had to line up, including a president, like Jordan said, that would not get 3 nominations in one term. Highly unusual. And then have the guts to get it through. And then, of course, then you have to get the decision. And there's a lot at play in these decisions, and we saw a great win here. But the fact is, this is what we need to reiterate. The constitutional right, so-called, to abortion does not exist in the United States Constitution.
Right.
That is what the court decided
It was
today.
said over and over, and that was the right decision. You cannot read the Constitution and find a right to abortion, and that's what they acknowledged today, and that was the right thing. And we are joining a vast majority of countries. This is not a strange, extreme decision. Protecting life is the right thing to do.
Justice Alito, who I've had tremendous respect for almost 25 years, 30 years now, I will tell you something. This was his magnum opus. This was his moment, and what a decision. And I think he eviscerates the dissent, who acknowledges there's not really a constitutional, firm foundational foundation for any of this.
This is the first step. It's a long first step, but it was the first step in the major fight to get this back to the states where we can have the direct dialogue, both political and legal, to the people, where it's not just this Washington, D.C. issue and federal issue. And that is huge, folks, that we can take the battle to the states.
Justice Alito, in the opinion, said, this whole idea of arguing that personhood doesn't begin until the child is aware of their surroundings and has high cognitive capabilities. He said basically that's totally not true. That the person is a person.
A lot of people thought they would not see this day, not just from older generations, but even from mine, that you would see a day where Roe versus Wade was actually overturned directly.
When you get to the first substantive legal discussion in the opinion today in Dobbs overturning Roe versus Wade, the court starts the paragraph by saying, we discussed this theory, because this was a new theory that they started using to justify abortion. They said the one additional constitutional provision that respondents have now offered as yet another potential home for the abortion right, the 14th Amendment. The court concluded that rational basis, you could protect the life of the unborn. It returns to the state. There was no constitutional home for the right to abortion in the 14th Amendment. Bray versus Alexandria. Opposition to abortion is not discrimination against women. Who would have thought that a case we argued in 1991 and again in 1992, decided in 1993, based on activities that took place in 89 and 1990, would end up as one of the bases for this critical Supreme Court decision. But there it is. That brief is now 30 years old. I don't want to get emotional on this, but I am going to say that your support of us all the way back then, and we were a much smaller organization. We had a handful of lawyers. But look at the result that God gave in a case like this.
Again, we know the battle will return to the states. There's different ways that will happen. There will be states that already have trigger laws that are going to affect today, about 13 of those. There's going to be another 10 or 12 states that are ready to go, but they might have to do a constitutional amendment. They might have to change something in their legal system, but they're ready to go. So about half the country is going to put in very pro-life legislation. And then you're going to see battles. There's going to be the purple state battles, and then there's going to be the blue state battles, the extremist states that want abortion on demand until birth, or even, they're talking about perinatal in some states. But today we celebrate what has been a long strategic path to getting to this point to overturn Roe versus Wade. That began the day the court issued that decision in 1973.
There's another case we had, which is Hill versus Colorado, which was a distortion of the First Amendment, and the rules changed when it was free speech involving protesters that had a pro-life message. And we've called it, as Jordan just said, the abortion distortion factor. We won a couple of the cases. We lost one in particular, Hill versus Colorado. But here's what happened today. The 5-justice majority, in the opinion by Justice Alito, says this: the court's abortion cases have diluted the strict standards for facial constitutional challenges. They have ignored the court's third-party standing doctrines. They have disregarded the standard res judicata principles. In other words, case is closed. They have flouted the ordinary rules of severability of unconstitutional provisions, as well as the rule that statutes should be read where possible to avoid unconstitutionality. And they have distorted First Amendment doctrines as well. And the case they cited for that is Hill versus Colorado. And now you have 5 justices of the Supreme Court saying that the decision in Hill versus Colorado was a distortion of First Amendment principles. So it's, in a sense, a double win for us today, and a double win really for the First Amendment. But I think the takeaway here, we'll get to calls in a moment, the takeaway here is that Roe versus Wade it's gone.
When we take this to the states, these politicians can't hide behind Planned Parenthood, Washington, D.C., and Roe versus Wade.
Right.
They're going to have to vote. Your state legislatures are going to have to vote on whether or not they're going to allow infanticide in their state. That's a lot different than saying, well, we can't do anything about it because there's this Roe versus Wade decision. So you're going to be able to hold politicians who maybe have run this pro-life at the state level for a long time. You're going to know who's really pro-life. You're going to know the governors that are truly pro-life, the attorney generals. Now, some of them have steps to work through. So I'm not going to say that every state can't do the trigger law because they've got bad court decisions or they might need a constitutional amendment.
But not today.
So that is not for today. I mean, we've got all that ready. It's already prepared. We're already ready to go. We have ACLJ action that we launched just for this moment. But for today, we celebrate because you had to get to this point to even start that battle.
Today, the court, and I think this is personally very gratifying for us, and it says, as I'm reading from the opinion on page 11, and as the court has stated, the goal of preventing abortion does not constitute invidious discriminatory animus against women. Accordingly, laws regulating or prohibiting abortion are not subject to heightened scrutiny. That is the linchpin of the case, because heightened scrutiny, strict scrutiny as it's also called, is a very high burden. Rational basis protects the life of the unborn child. That opposition to abortion not being discrimination against women, CC, was a huge decision in 1990 and 91, but it's even bigger today.
To those pro-life protesters who engaged in civil disobedience in the 1980s and 90s, bringing the country's attention to this issue, waking up, especially the Protestant church and evangelical church, to what was going on in our country so we weren't afraid or it wasn't taboo to talk about abortion anymore and to tell people what abortion really was about and how women were being lied to and misled by Planned Parenthood and these abortion clinics. Again, we are up against $1 billion industry. They're not going anywhere. The fight will continue, but this is a day to celebrate.
Those justices that went through those unbelievably difficult confirmation hearings, Clarence Thomas, Brett Kavanaugh. I think about Justice Scalia today. He was the one who wrote the opinion in Bray that said opposition to abortion is not discrimination against women. They were champions too. They are champions. And I'm sure Justice Scalia is smiling from heaven today. He was one of the greats of all time, and he wrote the opinion in Bray. And, you have to think about those today and the difference it's made.
Roe versus Wade, just to say it, has been overturned by the Supreme Court.